SJC-12035, Service Employees International Union, Local 509, Reed, Massachusetts Department of Mental Health, and others.
Mr. Russell, good morning. When you're ready. Now, we have two of these cases. This is the DMH case, not the... Right.
I'll do my best to keep them straight.
Okay, good. It's easier for you than for us, so...
May it please the Court, my name is Ian Russell, and I represent the plaintiff appellant SEIU Local 509. This is the second time this matter is before this Court. In 2014, this Court held that the plaintiff, a labor union, had standing to pursue a declaratory judgment action alleging that the Department of Mental Health had violated the privatization law, or the Pacheco law, by privatizing case management services without first complying with the requirements of the law. The Court determined that the union had sufficiently alleged an injury arising from the Department of Mental Health's actions by alleging that the union had been prevented from exercising its rights under the law, and further by alleging that approximately 100 of its members had been laid off as a result of DMH's actions and failure to follow the privatization law.
Could you remind us of the chronology? The union at that point had objected to the department's...
So the...
To begin with, hadn't there been an objection by the union to the department's plan? The department said it was not a privatization agreement, and then that went to the auditor, but that took some time.
Yes. So prior to DMH entering into the privatization contracts, or what the union alleges are privatization contracts, the union did raise an objection with the auditor.
And did so promptly, as I recall.
And did so promptly, well before the contracts had been signed. But because because DMH did not submit a proposal to the auditor did not initially make an objection or an approval. Essentially what happened was DMH did not treat the contracts as privatization contracts, so they were never submitted to the auditor. Eventually, after the union had objected, but then after the contracts were signed later in 2009, so the contracts were signed later in 2009, then in 2010, the auditor did issue a memorandum.
Was it the auditor or the general counsel of the auditor?
It was signed by the general counsel for the auditor.
So it wasn't an official auditor, was it?
We treat it as an official finding by the auditor. It was true that it was not submitted under Section 55 of the law, because Section 55 assumes that the privatizing agency will send the proposal to the auditor, and we concede that that did not happen in this case, and that's why we're here.
And then the auditor's letter was sent on to the AG, and the AG did nothing.
Yes, the auditor's letter was sent to the Attorney General's office for any appropriate action.
And then nothing
and the
then
party...
then nothing happened, basically.
And then the Attorney General, after discussions, did not take any action.
And so the Attorney General has criticized the union for not having brought a action for injunctive relief.
Yes, there's been a fair amount of criticism from the department regarding the speed with which the union moved in this case. So as I just explained, the union first went to the auditor, then it went to the Attorney General hoping some action. It was only after it was clear that no action would be taken, and prior to the expiration of these contracts, that the union filed an action in the Superior Court.
What year was that?
That was 2012.
And then the position of the government was that you didn't have standing.
At that point in time, yes, the position of the department was that the union did not have standing. They were essentially arguing that there were no post-contracting remedies whatsoever, Their position being that if the department did not submit a proposal to the auditor, then that was the end of the game. There was nothing that could be done. So,
It's not that clear what you're supposed to do from this statute, is it?
well,
I
it's
mean,
not, at the time, prior to this court's order in 2014, which found that the union did have standing and that and that they had acted appropriately by seeking declaratory judgment, there was no guidance regarding what a party or a labor union injured by an action in the privatization process was supposed to do.
let me ask you while we're on that. In the first decision, the court said your standing was based on the injury to the union's rights to counsel its members and so forth. Now, the DMH is saying that your case is moot. So what is it that is still outstanding? What is the injury that is ongoing now that the contracts have ended? I mean, what is it that the court can do for you?
So what I would like to point out is that this is not a situation where, unlike some other cases where when a contract expires, the duties related to the contract have ended, and you can't seek to enjoin anything, you can't seek any other action. Here, the parties stand before you in essentially the same place the parties were at in 2014. The union remains
Of the
injured.
extensions? Is that because of the extensions or
And-
just because the original contract still gives them rights?
Well, the original contract, we believe, still gives the union still has rights to challenge it, but the services that are at issue here are still being performed.
The
They're
statute
still being, sorry.
The statute specifically exempts renewal contracts. The concern that's been voiced is how long are these contracts subject to challenge?
Well, so there are two rulings that the Superior Court made in particular related to standing. One was that because there was no remedy, that the union couldn't get anything based on the initial violation. So we do argue that there are various remedies that could be provided to the union arising from the initial violation when these contracts were initially in
What
place.
exactly? What? Such as what?
So the union there are various things that the union has spelled out in its brief, one of which would be reinstatement of
But that's not a remedy for the union, that's a remedy for the individuals. And the individuals are not parties to this litigation.
Well, the union did initially and has consistently argued that it had both direct standing and associational standing. In 2014, this court did not address the question of associational standing because it had found that the union had direct standing, so this court found that it did not need to reach the question of associational standing. But we continue to take the position that we do have associational standing and that reinstatement would be appropriate. It would not involve, and we have cited some cases in our briefing where it would not necessarily require the involvement of individual members. Their positions are offered and they are accepted or not.
Okay, but we need not decide that here, correct? I mean, this is a motion to dismiss.
Yes.
Which was allowed because they said it's moot because this is now a renewal contract and no longer an original contract. It was not allowed because they said there is no remedy still available to you even if it were.
I would disagree with that because the court did in fact say, before even getting to the issue of the renewal, said, well, you don't have any standing related to the initial violation because the statute doesn't allow for any remedies other than invalidation.
Is this Judge Sanders or earlier?
This was Judge Sanders.
Isn't the original complaint was that these weren't the same services, and that has never been litigated in the long history of this case?
The basis of the union's claim is that these
Well, the
services...
DMH said they were
Well,
not
yes,
the same.
DMH says they're not the same services.
That has never been litigated.
It has never been litigated. It was determined by the auditor, or the auditor's general counsel at least, that they were related, because that's why the issue was lettered and that's why it was sent to the Attorney General's office. So There was a finding by the court that there was no standing because, in part, because there was no remedies that could be available. So beyond reinstatement, we've said there are various other remedies that you could receive that are within the scope of the statute, being, hiring preference provided to people, rebidding the contracts under the provisions of the law. And we have pointed out that in cases even where the contracts were expired in the competitive bidding law, the court has recognized that because of the importance of the law and the importance of competitive bidding, that some remedy can be offered even if it is not the invalidation of the contract. But because
That makes a lot of sense in this case, too, because I take it June of 17, these all come up again, right?
yes, so these are.
So if you had a declaratory judgment in your favor, ultimately, I mean, I agree with Justice Gaziano that there's been no adjudication of whether they are or aren't similar.
Right, no court has ever dealt with that question.
Right.
Yes,
But assuming hypothetically that you were to prevail on that, declaratory judgment would give you and your members a step forward come June of 17.
it would. I think that all parties would have to concede that the anticipated end of the services, and whether or not the same providers end up providing them if they're rebid, we don't know, but the services are set to end on June 30th of 2017. And just because I'm short on time, I will address the issue about invalidation and about the subsequent agreement language that the court also relied on. Beyond saying that there was no remedy for the initial violation under the initial contracts, the court also said that the union could not seek invalidation of the contract because they had been, because the contracts had been renewed. And in order to
More
reach...
than that, isn't it? Isn't it more than that? Section 53 defines what a privatization contract is before you even get to Section 54, and it's not limited to renewal. It says any subsequent agreement, and then it goes into including.
Right, and our position is that, as with any other statute, you need to read it as a whole. And when you look at Section 54, it makes clear that an agency is not allowed to make a privatization agreement without first following the requirements of the law. And where a statute prevents an agency from making an initial privatization contract, that initial contract or privatization contract or whatever you want to call it needs to be treated as void under the statute. It could not have been made. Therefore, the only way that you can apply the language in Section 53 related to a subsequent agreement would be to ignore the fact that the initial agreement was void.
Which leads to the certainty argument, and this is in your case, but if someone sought to challenge the privatization agreement and sat on their hands, and we had a series of renewals, and about the fifth renewal, the party said, aha, it was invalid. Doesn't that give the opportunity, isn't that unfair? It doesn't allow the agency to have any certainty with its vendors?
The court, in the 2014 decision, addressed the problem of a party sitting on their hands, and they pointed out that a declaratory judgment action generally has a 3-year statute of limitations, and also that a party would be risking a laches argument if it did nothing. I feel that there is really the risk that is raised by the department about, and other parties, the amicus, about challenging renewal agreements down the road is not a real issue. If no challenge has been made, within the first 5 years and then moving into a second agreement, it is very unlikely that any challenge is going to be recognized by the court for reasons either of a 3-year statute of limitations under declaratory judgment or...
The thing is, this is a somewhat sui generis matter because of the uncertainty of the law as to whether the union had any ability to bring suit in the first place, which has been clarified.
The department hammers the union, frankly, endlessly about the timing and the speed with which this moved. But the union filed before the contracts were expired, after taking various other steps. And the only reason that there wasn't even a discussion about an injunction, let alone that they didn't raise the issue of renewal before the court previously or before us previously, but is also because in 2014, these were renewed at a point when the union had no standing. It was after oral arguments and before this court issued its decision in August of 2014. The union wasn't in the position to do anything. So I would agree that in the future, it's very unlikely that this situation will arise again. It's only because there was no guidance from the statute or from the courts that we're in the situation that we're in today. So our position is that we can get a remedy based on the initial violation, but also because under the statute, the initial contract, at least for purposes of motion for judgment on the pleadings, has to be treated as a nullity.
Well, she was explicit in saying she definitely said it was a privatization agreement. She assumed that,
She
being
assumed
Judge
that
Sanders.
based on she assumed that fact to be true based on the allegations in the complaint.
And you're saying that's the fundamental flaw, because it can't be a privatization agreement if it should have gone to the auditor and did not.
Yes, in which case it is, under the clear language of the statute, it is void and therefore a nullity. And our position is you can't have a subsequent agreement, as the language in 53 is, that follows after a nullity.
Okay, thank you.
Thank you.
Ms. Alvarez, good morning.
Good morning, Your Honors. Iraida Alvarez, Assistant Attorney General on behalf of the Department of Mental Health. This case is moot. For a declaratory judgment to issue here, there must be a live and actual controversy, and there is not a live and actual controversy here where the contracts that are the subject of the operative complaint expired in 2014.
Let me
But-
ask you a question. Where does the right to renew come from?
Well, the procurement process in this case, which began with the request for responses that were published in 2008, contemplated that it would consist of one contract for a duration of 5 years, as well as 3 options to renew for 1 year each.
I didn't see the contracts in the record, but maybe they're there.
Yes, Your Honor.
So I guess my question is, ordinarily, a contract that's entered into between parties may have a renewal provision or an extension or a right to, extend or an option to do so. But it comes within the right to do that is part of the initial contract rights. And I can't tell if that's what's going on here.
That is correct, Your Honor. That was part of the request for responses that were published here, and they are
So that's part of the original contract.
That's correct, Your
So
Honor.
if the original contract is no good, and then the right to renew only comes from that contract.
Well, I wouldn't agree with that, Your Honor, because the renewals, as a matter of contract law, stand on their own.
No,
They're
only
supported
if-
by them.
Here's the thing. If you have a contract and it gives you a right to renew, or it gives you a right to extend, or it gives you an option, and that contract is declared invalid, then I don't understand how it is that any of its provisions would have vitality, allowing for the exercise of those rights, which are only in place because of the contract itself.
Yeah, well, it is our position that the original contract here is not void, because it is not a privatization
No, I understand that's your
contract.
position, but if it is void, then what happens to the right to renew?
Well, if the contract was void, there's nothing that says that the renewal contracts would be also considered invalid, because the provision in Section 53 explicitly says that renewal contracts are not to be considered privatization
And that's
contracts.
assuming a lot, but I'm just saying, if you take into account regular contract law, just ordinary contract law, and it's the basis for a renewal or an option to extend is within the original contract, and if the contract itself is invalidated, whether because of fraud, or you name the number of reasons why a contract could be invalidated and declared null and void, then it seems to me any rights that flowed from that would be in question.
Well, Your Honor, one clarification. I know that the request for responses do include the provision about the renewals. I'm not sure if the actual standard contract forms that were at issue here.
In the record, the
Yes,
contract?
Your Honor, they're in the record appendix of the case.
I missed that.
Yes, the requests for responses are starting on page 121. Only portions of them are included here, which have the parts about the initial duration of the initial contract, as well as the duration of the initial contracts. And
We have the initial contracts?
The initial contracts are also here, beginning on page 137, and it's basically a standard contract form that the Commonwealth uses that, lists, the cost of the contract, as well as, the signatures and sort of the key provisions. But I'm not sure exactly if the renewal portion is in the actual contract. But I do know that it was included, and that was the anticipation when the procurement was conducted under the request for responses.
So let me understand your position. I'm not suggesting this was the intent here, okay? But let's put aside this case and let's imagine that DMH is going to be bringing in a private agency to replace a whole set of state employees, plainly something that should go to the auditor. But you decide you don't want it to go to the auditor for whatever reason. You say the contract will have a 1-month duration and may be renewed after that. So you basically ignore the obligation to go to the auditor. The union is slow to react. They react a month and a half later, and you say, too late, it's now a renewal contract and it's outside the scope of the Pacheco law.
Your Honor, I think the way the statute operates, it leaves the decision whether a contract is a privatization contract in the first instance to the agency. And in this case, the department determined that the services were not substantially similar, and therefore
I understand that. I'm assuming the good faith. I'm not suggesting bad faith, but the fact of the matter is the auditor did not, at least the general counsel to the auditor, did not agree and specifically said the facts in general and the statistics in particular indicate that at least a portion of public services was moved from state employees to private employees without following the provisions of the Pacheco Act. So general counsel says you should have come to the auditor.
Okay. So in general, the contract process, the bidding process, is one that's public. So the union or other private parties would be on notice that the contract, such a contract would be.
What else could the union have done in this case?
Well, they could have initiated litigation at that point. Now we know, after this court's decision in 2014, that unions have direct standing to challenge these kinds of determinations by the agencies, whether a particular contract is a privatization contract or not, before it even gets to the auditor.
But you're missing at least my question. I'll let Justice Gaziano ask his in a moment, but so the way you get around this is you just have a very short contract duration and then move to renewal, and therefore you basically undo the ability of anybody to get in your way because you say, sorry, it was a 1-week duration, too late, we've renewed.
I mean, I think that is unlikely. I think the public contracting process.
I'm not saying it's unlikely. The question is, would it be lawful? You say that. Are you saying that that's lawful?
I would think that if it's indeed, if in your hypothetical, if it was indeed a hypothetical contract and they did enter into, for a short-term duration, a union could challenge it, it could prevail in that case. But the situation in this case is that the union did not take any steps to secure a timely resolution of the issue of whether the contracts were privatization contracts.
How can you say that? Before the contract was in 2009, the same year, they went to the auditor, didn't they?
They did go to the auditor, but they did not initiate any litigation or.
Well, but how were they supposed to know what to do since the law doesn't deal with it? I mean, that seems.
Well, that's right, but I think once the statute, for instance, contemplates that the auditor needs to act promptly. The statute
How
gives
about
them.
the Attorney General?
I'm sorry?
And the auditor did not act promptly
Correct,
here,
and the
neither-
auditor did not act.
Neither did the Attorney General after that.
Well, the Attorney General did not take any action. We don't have any information on the record why that was. The statute, as this court said in its earlier decision, is not self-enforcing. The private party has to bring the matter before the court
Has
to
there been
seek.
any determination that the union was guilty of laches here? You're assuming that argument is going to prevail, but I mean, I think that there is an alternative point of view on this.
Well,
and
you're-
where there's been no determination that the union has, I mean, in the future, we've said, don't sit on your hands. But that's why I was suggesting perhaps this is a sui generis matter, because it was all so unclear what the law was and what the union's rights might be. I find it difficult to believe that an action brought in the way that you're suggesting should have been brought would have been anything other than shot down in the same way that it was shot down later for lack of standing.
Well, Your Honor, I think with regard to the laches argument, Your Honor, the defense was raised. There hasn't been any litigation on that point because of the disposition of this case on a couple of instances before the Superior Court. But the reality is that by the time this case reached this court for the first time and the contracts were imminently about to expire, the union should have sought an injunction to prevent the contracts from being renewed, and they didn't do that. They simply, when the case was remanded, amended their complaint to add the private contractors, the service providers as parties, and did not take any other steps to ensure that the contracts were enjoined.
The union's fault, you're saying.
Well, I'm saying that the union should have taken more timely steps to secure a resolution of that issue. Were it not for that fact, we would be in a different position today.
Well,
Maybe
just
able to
assume for a minute that you lose on the mootness issue. Is there any other interpretation of Section 53 that makes sense other than it's intended to avoid the inconvenience of a contract that's already assumed to be valid? Otherwise, that provision makes no sense. It's not intended to validate an invalid contract. It's intended to avoid the kind of procedural issues that you may encounter with an already valid contract. So I don't understand how DMH thinks that Section 53 is the answer to its problem here.
Well, Your Honor, I think the language in Section 53 is clear, that any subsequent agreement, including any renewal of the contract...
I know what it says. I'm thinking about purpose here, okay? Purpose animates interpretation. And if you think about the purpose of it, it's not intended to allow the agency to avoid what it should do in the first place. It's for another reason that we have that language there.
Well, Your Honor, I think the reason why the language is there is because the legislature was concerned about the timely resolution of, potential challenges to the validity of a contract, the disruption of services to the consumers, and to provide some certainty.
But wouldn't that be provided in this case? Because we have a challenge to the initial contract, and if there is no initial challenge, then the contract has certainty, correct?
If I understand Your Honor's question correctly, yes, in this particular case, there was a challenge, and it hasn't been resolved in a timely fashion. By now, the contracts are expired, and we are not only in the first or second renewal option, we're into the third renewal option.
It goes to Justice Link's point that this is a sui generis situation here, correct?
Yes, I mean, I think this situation, as I argued in my brief, is something that will likely not arise again, and that goes to our mootness point, because the narrow issue in this case is whether the 2009 contracts, which are the subject of the complaint, were privatization contracts or not, and those contracts have ended, they have expired, and that particular question will likely not arise again, and the statutory scheme and the rights given to the union by having direct standing is not one that would make likely to evade review.
It does evade review completely, because if your argument prevails in this case, assume hypothetically, as the judge did, that this was a privatization contract. It was improperly not treated as such. That gets into renewal. There has been never any compliance with the privatization law, ever. And you cannot tell me that in 2017, at the end of June, the department isn't going to continue to offer these services in a private fashion.
Well, Your Honor, I think that the statute is what the Superior Court assumed here was when it was looking, this came up actually as a motion for judgment on the pleadings, where we actually also argued the merits, was that it had to assume that the services were substantially similar. And in assuming that the services were substantially similar, it concluded that the case was moot because even though that would have made the contract subject to the Pacheco law, the contracts had already expired. It was a duration of 5 years. And the court then went on to analyze whether then the fact that there were renewal contracts would have saved the case from mootness. And the court said that even assuming that there were, by virtue of the language in Section 53, the contracts were simply not privatization contracts, and therefore the renewals themselves are not subject to the requirements of the Pacheco law. And further to that point, there's mechanisms when a private party like the union wishes to challenge whether there is a privatization contract, whether something is properly deemed a privatization contract. There are mechanisms within the statute, not only the ability to bring an action because it has direct standing to challenge that, but also it could seek expedited relief. It could have added, there were some delay because they did not add the necessary parties from the get-go.
But this is, again, this is motion to dismiss. You're not suggesting that laches is an appropriate grounds to dismiss. So how does that,
Well,
I mean, let's assume that they could have done something faster. Is that a basis to dismiss their claim?
Well, I mean, it's not necessarily a basis to dismiss their claim. It's just that the case was moot because there's nothing that they could gain from the only remedy that they're seeking in this case is declaratory judgment. That statute does not provide for any other remedy other than that.
But then go to Justice Bouncer's point. What if the declaratory judgment was that this agreement expires on June 30th of 17? There's going to, that a declaration is that this indeed is within the scope of the Pacheco law, and going forward, you'll have to comply with it. Would that not be something the court could do, even if it would make Mr. Russell unhappy that it may not provide back pay for members or other things, but is that something that the court could do?
Your Honor, I don't think so because at this point, we don't even know what those 27, what is going to happen once June 2017 is going to come. I think it would be for the court to assume too much as to what services or what not would be provided. And there has not been a determination at all in this case as to the factual issue about the services. And it's always been consistently the department's position that the services are not substantially similar.
Doesn't the auditor have the final word on that?
Yes, if the contract had been submitted to the auditor in the first instance, so that, for instance, if there was a new contract in 2017 and it was submitted to the auditor could review that and then issue a determination on that issue. But at this point, we don't even know.
If the auditor were to object, you would not have a valid privatization agreement.
I mean, I think the statute says that the auditor's decision is final and binding on the agency, yes.
But without relief, because this contract has already been, I take it that your position in June of 17 will be, hey, we've already done this, so this is a second contract and the Pacheco law doesn't apply.
Well, Your Honor, I cannot speak to that. I'm not sure. I'm actually not sure what the plan is coming in 2017. I think that remains to be seen. I mean, in this particular case, we are concerned, or the allegations pertain to the 2009 contracts. I don't know, the complaint is not making any allegations even about the renewals here. So I don't think it's appropriate to take that into account.
Could we go back to Section 53 for a moment, please? The legislative intent of the definition may not have been simply the overall implementation of the Pacheco law, but to make sure that initial contracts are protected so that providers and those people who need TMH services have some consistency of services. Isn't that your position on interpreting Section 53?
Yeah, I mean, Your Honor, that's correct. So if the court does not have any further questions, I will rest my briefs. Thank you.
Thank you.